Subcommittee will come to order. Good afternoon, everyone. How's everybody today? Very colorful. I enjoy the yellow and the blues. Livens the place up a little bit. We are here to discuss 12 bills that would benefit veterans and their survivors. These bills would ensure that veterans, their caregivers, and their survivors all receive fast, accurate, and fair decisions on their claims for VA benefits. Bill on the Veterans Appeals Improvement and Modernization Act of 2017 by further streamlining and modernizing the VA appeals process. Provide employees from across VA the technology, training, and resources they need to efficiently process and decide VA claims and appeals. Ensure that rural veterans can receive disability compensation exams where they are. Expand survivors' benefits and ensure that fallen service members and veterans are properly commemorated. And require VA to obtain and track necessary information concerning disabled veterans who have died by suicide. I am proud to have one of my bills on today's agenda. H.R. 3983, the Veterans Claims Quality Improvement Act of 2025, would ensure that veterans and their families receive accurate and fair decisions on their claims and appeals for VA benefits. The VA Board of Veterans Appeals has reported to Congress quality rates of roughly 95%. However, the subcommittee has learned that these ratings are quite possibly flawed. We have heard that the way the board calculates quality does not fully account for the legal errors identified by the U.S. Court of Veterans Appeals. In fact, the court reported in 2024 that 83% of board appeals were returned to the board because of legal errors. Many of these mistakes the board continues to make over and over again, and for too long the board has been passing the buck to the court, leaving the veterans waiting longer for a decision on their claims. This bill would change that and would require the board to carry out a robust training and tracking program using the proper data measurements so board judges and attorneys can learn from their mistakes. When the Veterans Benefit Administration at VA denies a benefits claim, that veteran has the option to appeal to the board. We have heard that the board often sends veterans' cases back to the VBA instead of deciding the claim. In fact, the board reported it sent back nearly 50% of all the appeals it received in 2024. This is unnecessary and remains a waste of time and resources. This can add months or even years to the wait times for a veteran to receive a final decision on their claim. Again, this is unacceptable. It's the responsibility of the board judges to ensure that all remands are correct, fair, and timely. Under the current law, performance reviews on board judges are only required every 3 years. This bill would change that, requiring board judges to undergo annual performance reviews. This bill would also hold VBA claims processors accountable for avoidable deferrals of veterans' claims. It would ensure that when a VBA claims processor mistakenly requests additional evidence for a veteran's claims, all claims processors who may have made the same mistake on that case are notified, not just the last one to work on the claim itself. It provides an opportunity for the claims processors to correctly address claims going forward and become better at their jobs. And the VA has a hard job nonetheless, but veterans deserve a claims and appeals process that puts them first. This bill helps make sure that we have an adaptable VA that learns from its mistakes to better serve our veterans. Chairman Bost, chairman of the VA committee, and I have both gone through the disability claims process ourselves, and it is a top priority for us to ensure that the process works for every veteran, caregiver, and survivor. I look forward to working with Chairman Bost, Ranking Member McGarvey, and other members of this subcommittee on this important proposal today. I look forward to hearing from witnesses who have joined us today and how we can improve these bills. I now yield to the Ranking Member for his opening remarks.
Thank you very much, Mr. Chairman, and thank you all for being here today. We got a packed agenda with votes coming up soon, so I want to be brief. First of all, Mr. Chairman, thank you for your willingness to continue to work on this committee in a mission-focused manner, a bipartisan way that looks out and cares for our veterans. We've got a lot of good bipartisan bills here today, and you've always been willing to work through some of the issues we may encounter in creating not just well-intentioned, but also well-functioning legislation as we move forward. I'm happy to see Ms. Brownlee's bill, the Veterans Law Judge Experience Act of 2025, on the agenda today. This is a great bill, dovetails with one of the efforts I've worked on with the Board of Veterans Appeals Attorney Retention and Backlog Reduction Act, because it further emphasizes the need to hire and retain the best and most qualified attorneys and judges on the board. This helps our veterans. This helps our veterans who are already having trouble getting through the system. And I look forward to hearing more about legislation that seeks to find ways to make the Board of Veterans Appeals and the Court of Appeals for Veterans Claims work more efficiently for our veterans, for for their families, for their caregivers, for their survivors. Again, this is about how do we help our veterans. That said, there are quite a few concerns with some of the agenda items related to appeals that I hope my colleagues in the majority will work with us to address prior to moving these bills further through the process. Mr. Chairman, one of the bills we'll discuss today, the Caring for Survivors Act of 2025. It's a long overdue act to improve compensation for survivors, for the survivors community, and I strongly support it. The rate of dependency and indemnity compensation for surviving spouses and dependents was set in 1993. Just to date myself here, that's when I was in the 7th grade. So I think that we can do a little better in updating what is due to our veterans, their spouses, their families. They put on the uniform to sacrifice everything for us. We've got to do right by them. Needless to say, the world's a little different today than it was in 1993. And despite what decisions were made back then, we know today that right now that survivors of our nation's brave men and women deserve more than we are giving them. Let's do that. It's long overdue to justice compensation for people who have already paid dearly for this country. It's time to stop making them stretch their dollars as they continue to sacrifice and stretch themselves to their emotional limits. And while I acknowledge that every expansion of benefits does come with a cost on it, there is a difference between spending and investment. And we have to continue to invest in the people who are willing to put on a uniform so that we have people who are willing to put on that uniform, that they know that the promise that we make to them in exchange for their service will continue to be honored after they take the uniform off. So again, I thank you, Mr. Chairman, for this hearing. I thank the experts and advocates for being here today. And I look forward to coming up with practical, workable solutions for those we hold most dear here in this commission.
Thank you, Mr. McGarvey. Chairman Boss, sir, you're now recognized for your opening statement.
Thank you, Chairman, and I want to thank you and the ranking member for holding this hearing today, and I'm proud to have introduced 2 bills on the agenda today. One of my top priorities is continuing to streamline the VA's appeal process. That's why we must continue to build on what was accomplished through my bill, the Veterans Appeals Improvement and Modernization Act of 2017. My new bill, H.R. 3835, the Veterans Appeals Efficiency Act, would provide tried and true legal tools to the VA Board of Veterans Appeals and the U.S. Court of Appeals for veterans' claims to effectively decide veterans' claims that are on appeal. Even with the massive investment Congress has made in the board, some veterans still are waiting up to 5 years for the board to decide their claim. The board still has 200,000 appeals pending and receives over 65,000 appeals a year. Currently, the board is only able to address roughly 120,000 appeals each year. At this rate, there's no way the board can eliminate its backlog. Simply giving millions more in tax dollars to the board to hire more staff is not the answer. We must authorize new tools and processes for the board to modernize whether they want to or not. The board already has the authority to decide appeals in whatever order it needs for the good cause, and the veterans waiting years for decision is certainly a good cause to use this authority. For decades, other federal agencies have used legal tools like aggregation to decide large number of similar claims at the same time. My bill would require the board aggregate veterans' appeals according to the best legal practices. It's time for the board to catch up with the rest of the government and use aggregation to provide the veterans with faster decisions on their benefit claims. Even the court recognizes the importance of this tool and began aggregation veterans' appeals in a process known as class actions. My bill would improve the process for class actions by allowing the court to certify class actions that include veterans waiting for a board decision on their appeal, closing this legal loophole and ensuring timely discussions for the decisions for the veterans. My bill would also codify the court's authority to issue limited remains limited remands, which all allows the court to order the board to fix specific mistakes it made in a veteran's appeal without requiring the board to issue a whole new decision. Each of these charges would make the VA, each of these changes would make the VA appeals process work better and faster. We owe it to our taxpayers to come up with new, efficient solutions instead of hiring more bureaucrats to continue a slow status quo. I would like to thank the ranking member, Takano, as well as Representative Valadeo, Bilirakis, Bacon, James, and Lawler for co-leading this important bill with me. My second bill, H.R. 3834, the Protecting Veterans Claim Option Act, would ensure that no appeal option becomes a trap for veterans. The AMA gave veterans more choices for how veterans can pursue VA benefit claim, but there are improvements to be made. My bill would close a loophole in the law that prevents some veterans from ever receiving a final board decision. Under current law, when the board decides that a veteran did not submit new and relevant evidence, the board refuses to make any decision on whether the veteran can receive VA benefits. The veteran's pursuit for VA benefits essentially disappears. My bill would ensure that the supplemental claim option is not a dead-end trap for veterans trying to navigate the VA appeals process. It would require the board to make a decision on the merits of the veteran's claim, regardless whether their supplemental claim contained new and relevant evidence. My bill would close another loophole in the appeals process by allowing veterans to submit additional evidence after the court sends their case back to the board. During the appeals process, veterans often learn that the evidence that they need to support their claim and find it later after they've filed. Veterans deserve fast and final decisions on their VA benefit claims, not a hamster wheel that forces them to wait months or even years just to get denied all over again. My bill would ensure that the process would work for, not against the veterans and their families. I look forward to discussions of both these bills in the future, and I yield back.
Thank you, Mr. Chairman. Ms. Brownlee, you're point of order. Each member will be held to 3 minutes for their openings, or for their remarks. We've got a long list. So in accordance with committee rules, I ask unanimous consent that Representatives Brownlee, Hayes, Barrett, and Mr. Kennedy be permitted to participate in today's subcommittee hearings without objection, so ordered. Representative Brownlee, you're now recognized for 3 minutes to speak on your bill.
Thank you, Chairman Luttrell and Ranking Member McGarvey, for giving me this opportunity to speak on my bill, H.R. 659, the Veterans Law Judge Experience Act, which would give hiring preference to veteran law judges that have 3 or more years of veterans law experience. Throughout my tenure on the Veteran Affairs Committee, I have seen how veterans can end up waiting years before their claims for veteran benefits are decided. In some extreme cases, veterans have even died while waiting for their claims decision, while others spend their time unable to work and struggle to make ends meet. These circumstances make it clear that a prompter VA decision on a claim would change a veteran's life. VA's fiscal year 24 annual report, the Board of Veterans Appeals had over 200,000 pending appeals. The VA cannot afford to hire judges with lack of experience practicing veterans law. Veterans need judges who can hit the ground running and get them decisions in a timely manner. Not only would my bill decrease the backlog of veterans' benefit claims, it would also improve the accuracy of cases and incentivize those with experience to stay in the field. I was disappointed to see VA as opposing my bill. It's perplexing to me that VA would not want to hire experienced judges in the field of law they would be actually practicing. I've also heard from employees with the Veterans Board of Appeals who strongly disagree with the VA's official position. These employees informed me of how many of the veterans law judges VA hires have no experience in veterans law. These judges then must undergo lengthy training periods and handle a reduced caseload while they become acclimated to the ins and outs of the law. This practice of hiring judges without veterans' law experience clearly further delays veterans from receiving their well-earned benefits. Judges should be able to immediately start digging into the claims backlog to get veterans their benefits as quickly as possible. Firmly committed to working with my colleagues on the committee to get my legislation signed into law, and I thank you for the time, and I yield back.
Thank you, Ms. Brownlee. Mr. Barrett, sir, votes will be called in around a minute. Will you be returning, or would you like to go?
I will be returning, so I can yield to another member if you'd like before votes, if that would be better for you, Mr. Chair.
Is there any other member that will not be returning after votes because of other committee assignments? I'm happy to yield their 3 minutes currently. Mr. Kennedy, anybody? Mr. Self? Okay. Mr. Barrett, go ahead for your 3 minutes, and then after 3 minutes, I'll gavel us out so we can go vote, and then we'll return.
Thank you, Mr. Chairman. Appreciate it, and thank you for allowing me to speak today, and to Ranking Member McGarvey, thank you as well for your willingness to take up this bill today. I appreciate the committee's consideration of my bill, H.R. 3833, the Veterans Caregiver Appeals Modernization Act. This legislation makes some critical and long overdue reforms and improvements to the Department of Veteran Affairs program of comprehensive assistance for family caregivers. This program is set up and designed to ensure that the nation's most injured veterans, those that suffer the most serious injuries, who choose to receive their care at home rather than in a hospital, not subjecting their loved ones to significant financial hardships and burdens. Unfortunately, the VA, the VHA, the Veterans Health Administration, which handles this program, doesn't have a unified system available for applications. As a result, the records and documents that are scattered across multiple platforms and on various different systems, the VA staff that manage that see different things throughout the process, and there's not a unified way of managing that, and oftentimes claims are delayed or lost or otherwise not actioned for quite some time. We're going to hear today from a caregiver about the personal effect that had on her and her family's life. It leads to delays, confusion, unjust denials, particularly during appeals, which can take years to resolve. This bill eliminates that bureaucratic roadblock that stands in the way between family caregivers and the VA. We're going to streamline and improve the VA's caregiver program application process for veterans and caregivers so they'll finally be able to receive timely and accurate decisions. It will also ensure that family members who put their careers on hold to care full-time for their loved ones receive the past due financial support they've earned. A glaring oversight is when a veteran dies while these applications are pending, are not able to receive any type of back-allotted benefits. I'm excited to hear testimony today, and I want to thank the witnesses for attending this hearing. And Mr. Chairman, again, thank you so much for taking this bill up for consideration today. And with that, I'll yield back.
Thank you, Mr. Barrett. A vote has been called in the House. The subcommittee will stand in recess, subject to the call of the chair. I expect to reconvene 10 minutes after the start of the last vote. Ladies and gentlemen, we have to adjourn to the House floor to have votes. I would like to promise you a timely return. However, comma, period, end of discussion. If you want to kick it down the road like that, we will wait for the House. For the first vote, usually goes a little long. I'd like to say we were going to be in and out in 15 minutes, but that would be me lying to you, so I won't do that. It is 1:30. I think it would be comfortable if you were to come back in around 2 o'clock, 2:05. Might be a good time. So Kennedy, sir, you are now recognized for 3 minutes.
Thank you, Mr. Chairman. Mr. Chairman, Ranking Member McGarvey, members of the subcommittee, thank you for the opportunity to speak in support of my bill, H.R. 2721, the Honoring Our Heroes Act. This legislation is rooted in the lived experiences of military families from my district and across the country who only came to fully understand the depth of their loved one's service and sacrifice years or even decades after they had passed. Families who were told by the government that their loved ones were ineligible for the same final honors afforded to other veterans. Under current federal law, the Department of Veterans Affairs will only provide a headstone or marker for veterans who died on or after November 1st, 1990. But before 1990, veterans were allowed to receive a government-issued headstone regardless of when they passed. This change was not enacted out of principle, but as a cost-saving measure to get legislation passed. Our veterans should never have been reduced to a line item. Their courage was not conditional. Their service did not come with a time limit, and neither did their grief of the loved ones that they left. I've worked closely with families impacted by this arbitrary policy. I've heard their stories, shared their frustrations, and felt their heartbreak. They are only seeking dignity and recognition for their loved one's honorable service. I've made every effort to help them navigate the VA's bureaucracy, requesting exemptions, filing appeals, only to be repeatedly met with denials and red tape. The Honoring Our Heroes Act seeks to change that. My bill will create a 2-year pilot program to allow families of veterans who passed before November 1st, 1990 to apply for a headstone or burial marker through the VA. This simple, compassionate change would mean everything to the families who've already waited too long for their loved ones to be recognized with the honor that they've earned. My bill has earned strong support from some of our most trusted veteran service organizations, including the VFW, Gold Star Mothers, Tragedy Assistance Program for Survivors, Vietnam Veterans of America, Disabled American Veterans, American Legion, including the Jesse Clipper Post 430 and Bennett Wells Post number 1780, the Military Order of the Purple Heart, including Buffalo Chapter 187, Janetta R. Cole's AmVets Post 24, the Veterans One-Stop Center of Western New York, and the African American Veterans Arts and Culture Corporation. This legislation is about doing right by our history and ensuring that those who wore the uniform are afforded the honor that they've earned. The uniform these brave men and women wore didn't change with the date, and their sacrifice didn't diminish over time. I respectfully urge the subcommittee to support H.R. 2721 and help ensure that no veteran's legacy is forgotten. Thank you for your consideration, and I yield back.
Thank you, Mr. Kennedy. In accordance with committee rules, I ask unanimous consent that Representative Stefanik be permitted to participate in today's subcommittee hearing. Representative Stefanik, you're now recognized for 3 minutes.
Thank you, Chairman Luttrell, and thank you for convening today's hearing on my bill, the Ernest Peltz Accrued Veterans Benefits Act. First, I want to thank this committee for your tireless work in advocating for our nation's veterans and ensuring their voices are heard in Congress. I also want to thank Representative Ro Khanna for co-leading this bipartisan legislation. It's an honor to speak before the Disability Assistance and Memorial Affairs Subcommittee to discuss my bill that corrects a moral wrong and seeks to improve the payment of pension benefits for those who selflessly served our great country. I proudly represent New York's 21st Congressional District, which is home to Fort Drum and the 10th Mountain Division, the Army's most deployed division since 9/11. Our district also has the largest veterans population in all of New York State. As members of Congress, it is our duty to recognize the sacrifices our military families make for our freedoms and develop solutions to ease the burdens placed on them. I look forward to continuing working with this committee to ensure our vets and their families are confronted with fewer hurdles when accessing their hard-earned benefits. My bill, H.R. 3123, the Ernest Peltz Accrued Veterans Benefits Act, improves the process by which our vets receive their accrued pension benefits. With one of the largest military communities in New York State, I've had the privilege of meeting with countless veterans and hearing firsthand the issues they face every day. Mr. Peltz was a U.S. Navy vet who bravely served in World War II. During the final chapter of his life, he lived in an assisted facility in Queensbury, New York, to be close to his son, Charles. His health began to rapidly decline, and the Warren County Veterans Service offices assisted Ernest with his application for accrued pension benefits, for which he was approved. I personally spoke with senior VA officials, yet due to a processing error at the VA, the funds were not deposited until 7 days following his death. This erroneous delay prompted the VA to then claw back the earned funds and abandon the Peltz family with unanticipated expenses while mourning the loss of Ernest. The Peltz family was penalized for the VA's mistakes. This is unacceptable. A family mourning the loss of a beloved veteran should not have to deal with red tape and bureaucratic mistakes. My bill ensures another family never has to go through something like this again. It eliminates the burden on the surviving family by ensuring that the veteran is entitled to receive their pre-approved pension benefits within the month the death occurs. When a service member serves, their family serves alongside them. Together, we have the opportunity to pass this common sense bipartisan bill to ensure our veterans and their families are never forgotten. Again, thank you for the opportunity to Chairman Luttrell today. I also want to particularly thank Ernest's son, Charles Peltz, who is a friend. I saw him last week. Thank you for your years of commitment to helping us pass this bill. And I yield back.
Thank you, Ms. Stefanik. Is it our practice we will forego a round of questioning for each member? Any questions may be submitted for the record. A vote has been called in the House. The subcommittee will stand in recess, subject to the call of the chair. I expect to reconvene 10 minutes after the start of the vote. All right, you guys call all your friends. Tell them we're ready to rock and roll. Okay. Committee will come to order. Representative Hayes, you're now recognized for 3 minutes to speak on your bill.
Thank you, Mr. Chairman. I appreciate the Veterans Affairs Committee for inviting me back to discuss my legislation, the Caring for Survivors Act. I had the opportunity to come before the committee last Congress to discuss the importance of the bill, and I'm here again today to share the broad support the bill continues to gain and the need to sign it into law. While I do not sit on this subcommittee, I deeply care about our veterans and have worked tirelessly on behalf of the men and women and the families who have served our country since I joined Congress. My bill, the Caring for Survivors Act, is a continuation of that dedication to our veterans. This legislation would expand benefits for survivors of service members and veterans who have given their lives in service to the United States. When a service member dies in the line of duty, or a veteran dies from service-related injuries or illnesses, their surviving family members receive a monthly benefit known as Dependency and Indemnity Compensation, or DIC. Unfortunately, the DIC rate has been minimally adjusted since the VA established the benefit in 1993 and is lower than the rate of other federal survivor programs such as the Federal Employees Retirement System. Specifically, DIC beneficiaries currently receive 43% of the rate given to a totally disabled veteran, which is significantly lower than the 55% of the insurance annuity that beneficiaries of federal civilian employees are eligible to receive. Additionally, current DIC rules drastically reduce the benefits for surviving members if the veteran was disabled for less than 10 years before passing away. This 10-year provision is more stringent than other federal survivor programs and disadvantages survivors who have put their lives on hold to care for a disabled veteran. The Caring for Survivors Act addresses these issues through 2 reforms to DIC benefits. First, the bill raises DIC to 55% of the rate given to a totally disabled veteran, increasing DIC to a level consistent with other federal survivor programs. As a result of this change, survivors will receive an approximate increase of more than $450 per month. Secondly, my bill reduces the 10-year disability rule to 5 years to broaden eligibility and expedite DIC benefits for veterans who have sacrificed to care for disabled veterans. Taken together, these 2 provisions modernize survivor benefits to ensure families receive the financial help they deserve. I appreciate the support of the VSO community for the legislation, and I also want to recognize the surviving spouses and other family members nationwide and in this committee room for their ongoing advocacy to implement essential changes to survivor benefits. Finally, I want to thank my Republican colleague, Representative Fitzpatrick, for leading this legislation with me in the House, as well as Ranking Member Blumenthal and Senator Bozeman for their support of the legislation in the Senate. Supporting veterans and surviving family members is an intentional choice that we can all make. I encourage my colleagues to support my bipartisan legislation and advance it through this subcommittee and vote for passage on the House floor. Thank you, and I yield back.
Thank you, Ms. Hayes. I now invite the second panel to the table. Ms. Juleff, you're left. You're right, and Mr. Wishney, you're in the middle. My fault. I should have thrown that at you.
One more over. Thank you.
You guys ready? All right. Welcome, everyone, and thank you to those who traveled here to share your experiences with today. Our second panel, Miss Julie Huliff? Okay. Miss Julie Huliff, surviving spouse of Stephen Huliff, Vietnam veteran. Professor Michael Wishney, William O. Douglas Clinical Professor of Law and Director of the Yale Law School Veterans Legal Service Clinic. And Ms. Candace Wheeler, Senior Director, Government and Legislative Affairs for the Tragedy Assistance Program for Survivors. I ask all the witnesses to please stand and raise your right hand. Do you solemnly swear that the testimony you are about to provide is the truth, the whole truth, and nothing but the truth to help you God? Thank you, and let the record reflect that all witnesses answered in the affirmative. Ms. Huliff, you are now recognized for 5 minutes to present your testimony.
Members of the subcommittee, thank you for the opportunity to testify today. My name is Julie Guliff. I'm the surviving spouse of 100% disabled Vietnam veteran Stephen Guliff. I come here today to speak in support of H.R. 3833, the Veterans Caregivers Appeals Modernization Act of 2025. To understand my strong support for this bill, I need to explain our story. Steve and I first met in 2004, and eventually we were married. I was still working 3 jobs to provide for my children and my mother, but was ready to reactivate my nursing license and continue my career. However, recognizing his growing needs, I put my life on hold to be a caregiver to Steve. With the titles of caregiver, nurse, and wife, my personal goals and career vanished. I had 3 jobs, but none of them came with the salary. With the increasing out-of-pocket medical expenses, our debt grew daily. Steve's health needs were clear. He couldn't drive, he couldn't go anywhere by himself, eat, or manage his own affairs. The PTSD was unmanageable and often frightening. In 2017, Steve's issues compounded once again. On top of everything else, we were now fighting prostate cancer. In 2018, we moved, and Steve was able to get a VA-backed mortgage to buy a house. The downside was that by this time, I did not have the credit to be added to the mortgage. Due to my caregiving responsibilities, I hadn't worked since 2010, had significant debt, and definitely could not leave Steve to go to work. In late 2019, we learned the prostate cancer had progressed to stage 4+. Steve completed 55 consecutive days of radiation, which caused severe side effects. He was now bedridden, completely incontinent, unable to stand, walk, or attend to personal hygiene needs. Moreover, the radiation had furthered his dementia, requiring more oversight, and then COVID hit. On October 1st, 2020, we were excited to learn that the PCAFC program opened to Vietnam veterans. I immediately applied to get some financial relief, as I thought my husband was more than qualified. I wheeled him into the bathroom, had to take him into the shower with me or wash him on a chair or brush his teeth, and managed all his medications. I had to hire someone to stay with him if I had to leave the house for any reason, such as grocery shopping. Due to the pandemic, our home visit and interview was done virtually. It must be noted that these virtual evaluations were not necessarily an accurate representation of our reality, as it's hard to see through a camera all of the medical equipment and the piles of pill bottles. My husband went to great lengths to not let people see him in his debilitated state. I spent endless hours on the phone, writing letters, emailing, faxing, hand delivering, and correcting errors with the medical documentation. The first denial came in early 2021 with the reason given that veteran does not need 6 months of continuous care. That was inconceivable to both my husband and me. We had already been through years of continuous care, home health, physical, occupational therapy, home modifications, and countless pieces of medical equipment. We were heartened in March of 2022 when, recognizing flaws in the system, the VA announced it was pausing dismissals from the program while the agency reviewed the eligibility criteria. Today, over 3 years later, caregivers are still waiting for the new regulations to address the problems. In August of 2022, we went bankrupt. Our finances had all been spent. We were buried in medical debt. We appealed the PCAFC decision multiple times. To be clear, if it had been approved, it wouldn't have solved all our problems, but it absolutely would have helped. Steve passed away on October 6 of 2022. Days after his death, I received a call from our mortgage holder asking me when I would be vacating our home. The company made it clear that they could not hold a mortgage for a deceased veteran. After years of sacrifice of career, credit, savings, and personal health, I was now widowed, homeless, alone, destitute, and heartbroken. Sadly, I'm not alone. Our PCAFC case was still open at the time of my husband's death, even after 2 years of fighting for a favorable decision. The overwhelming challenge of gathering and adding documents to the veteran's medical record is impossible in its current form. I struggled for years to connect the dots between providers in both the VA and outside to make sure records were up to date, inclusive, and complete. but CNN records sometimes never made it to Steve's file. CCN records sometimes never made it to Steve's file for use in treatment plans and certainly not for PCAFC eligibility. In the wake of losing Steve, I was so frustrated with the denials for PCAFC, I made it my mission to follow through with our quest. In 2023, I filed our case before the Board of Veterans' Appeals. Ultimately, I went before a judge in December of 2024. By the time I was done, he was in tears. Unfortunately, in March of 2025, almost 5 full years after we applied, we were denied again with the following conclusion of law. Due to the death of the veteran, the appeal for eligibility of PCAFC benefits must be denied as a matter of law. The board also noted it was only able to consider evidence of record at the time of the agency of original adjudication decision. After all our challenges, COVID interfering with appropriate care, evaluations, flawed regulations, changing staff, and the lack of appropriate record sharing, we were ultimately denied because the VA simply outlasted my husband. The VA is an enormous system and will always have challenges due to its sheer size, much less added complications like COVID. The board process is a way of rectifying those problems, but if the process ends when the veteran dies, those left behind are left to deal with the consequences. Please pass H.R. 3833 so that others won't suffer the same fate as me. Thank you. I look forward to your questions.
Thank you for your testimony, Ms. Hula. Professional Whitney, you are now recognized for 5 minutes to present your opening testimony.
Mr. Chair, Mr. Ranking Member, members of the subcommittee, thank you for the opportunity to testify today. My remarks reflect my own views and not those of Yale or of any of my clients. I speak today in support of the Veterans Appeals Efficiency Act, H.R. 3835, which contains practical reforms that would meaningfully improve the adjudication of VA claims and ensure that veterans have access to some of the tried and true tools, as Chairman Bost put it, that civilians have when they seek review of government decisions in federal court. I'll focus on just 2 points. First, the act would codify and expand the jurisdiction of the Veterans Court to aggregate claims that raise the same question of law or fact. Other federal courts employ aggregation to manage mass adjudications in agency contexts. In the Veterans Court as well, aggregation can foster more consistent, equitable, and fair application of judicial rulings, while also reducing the strategic mooting of cases by VA. There is no reason that veterans should be denied recourse to the same tools that civilians challenging government decisions have with other federal agencies. The Veterans Court has some authority to aggregate claims, and it has deployed this power judiciously. Already, tens of thousands of veterans have benefited. Many veterans cannot afford to hire the legal counsel or medical or technical experts necessary to argue complex medical or legal questions. Aggregation allows all similarly affected veterans to join together and to benefit from one well-presented case. Aggregation also advances judicial economy because it is more efficient to decide a question once than hundreds of times over and over. And aggregation promotes uniformity in decisions, avoiding the inconsistency of single-judge opinions on the same question, as we often have at the Veterans Court today. Now, when civilians challenge agency actions in federal court, they can gather together cases that have reached the court and that raise the same question, but are still pending down at the agency level. However, in a case called SCORE, the Federal Circuit recently held that the Veterans Court, unusually, is limited and can aggregate only those claims that have reached the court or are within the 120-day appeal window. Claims of other veterans raising the exact same issue that are languishing at the board or stuck before regional offices must be excluded. This is unusual in federal courts. Because few veterans with the same issue fall within that same 120-day appeals window at the same time, the SCORE decision effectively ends aggregation for veterans at the court. Recognizing the harsh consequences of this decision, 5 judges of the Federal Circuit objected. Judge Dyke explained for the dissenters that aggregation, quote, promised to help ameliorate VA delays to some significant extent, enabling veterans in a single case to secure a ruling that would help resolve dozens, if not hundreds, of similar claims, end quote. But the SCORE decision denies veterans the ability to, quote, compel correction of systemic error and to ensure that like veterans are treated alike. This bill fixes those problems. Now, the board's written testimony raises various criticisms, which I do not think are well-founded and which I would be glad to address during questioning. Importantly, even when the Veterans Court decides a single common question, VA still makes the ultimate benefits determination for each veteran on an individual basis based on that veteran's facts and circumstances. Briefly, there are two amendments I hope the committee will consider to this provision. First, I agree with the court in its written statement that H.R. 3835 should not narrow the court's authority in writ cases. I don't believe this was the intent of the drafters, and I've shared proposed amendments with staff to address this. Second, I hope the bill might avoid mention of opt-out procedures. The sensible structure of the bill is to incorporate the rules prescribed by the Veterans Court itself. The rules of that court do not explicitly address opt-outs. Removing mention of opt-outs from the bill would continue to leave it to the court to adopt such procedures, either generally or in a particular case. The second and final point I wanted to make about the bill is to emphasize that it would also codify the authority of the board to aggregate claims. So now moving from the court to the board. 70 other federal agencies use aggregation in mass adjudication settings, but the board is an outlier. It has held repeatedly that it lacks authority ever to aggregate claims together and decide once instead of hundreds or thousands of times, even when the appeals involve the same question of law or fact. According to the Administrative Conference of the United States, a result of the board's failure to aggregate is that, quote, agencies risk wasting resources in repetitive adjudication, reaching inconsistent outcomes for the same kinds of claims, and denying individuals access to the affordable representation that aggregation procedures promise, end quote. The bill would remedy that too. Oddly, the board says it doesn't want this tool. It wishes to remain disempowered, unlike 70 other agencies, ever to aggregate claims. It cites concerns about the manner in which it itself might exercise this power if it had it. But the bill does not dictate these details. It provides the tool and leaves it to the board to properly administer it. There's no reason to deprive veterans of a tool that civilians may invoke before 70 other agencies. In conclusion, I urge the committee to approve H.R. 3835. Thank you.
Thank you, sir. Ms. Wheeler, you're now recognized for 5 minutes.
Chairman Luttrell, Ranking Member McGarvey, and distinguished committee members, the Tragedy Assistance Program for Survivors appreciates the opportunity to testify on behalf of more than 120,000 surviving families we are honored to serve. TAPS remains committed to strengthening dependency and indemnity compensation for surviving families. DIC has only been increased by COLA since 1993. TAPS is grateful to Representatives Hayes and Fitzpatrick and 55 original co-sponsors for reintroducing the Caring for Survivors Act, which will raise DIC by $454 a month, providing parity with other federal survivor benefits and financial stability for surviving families. In the words of Amanda Pitzer, surviving spouse of Chief Petty Officer Larry Pitzer Jr., losing my husband changed every aspect of my life, emotionally, mentally, and financially. While DIC provides some support, the reality is that it simply isn't enough to keep surviving families financially secure. The gap between what is provided and what is actually needed forces many of us into impossible situations, choosing between paying bills, securing our futures, or being present for our children. If the Caring for Survivors Act is passed, it would be life-changing. TAPS appreciates Representatives Edwards and Morrison introducing the Justice for Americans Veterans and Survivors Act to ensure VA collects cause of death data for deceased veterans. While the VA currently supports 506,000 surviving spouses, VA does not know what percentage are suicide, illness, combat, or training accident losses. This data is critical to ensure VA and other organizations provide necessary care and programs for survivors, as well as research into suicide prevention, toxic exposures, and illnesses that have led to the tragic deaths of many of our nation's veterans. The lack of data also negatively impacts CBO scoring of survivor legislation like the Love Lives On Act and Caring for Survivors Act, adding to the cost of these bills and making it difficult to find funding. We urge swift passage of this important legislation. TAP strongly supports the Fallen Service Members Religious Heritage Restoration Act, which ensures every American service member who fought and died for our country has their beliefs and heritage properly honored. Many veterans from earlier generations also may lie in unmarked graves. The Honoring Our Heroes Act, sponsored by Congressman Kennedy, seeks to correct this oversight by ensuring that every veteran, regardless of when they passed, is honored with the dignity and recognition they have earned. TAPS also appreciates the Modernizing All Veterans and Survivors Claims Processing Act, which expands the use of automation tools across VA to improve efficiency, accuracy, and communication within the claims process. This legislation codifies the work being done by VA and ensures veterans and survivor claims advancements are protected in perpetuity. TAP strongly supports the Veterans Claims Quality Improvement Act to streamline the benefits claims process for our veterans and their families. We thank you, Chairman Luttrell, for your leadership on this important bill. TAPS also appreciates Chairman Boss introducing the Veterans Appeals Efficiency Act to help streamline the VA claims and appeals process, making it more expedient, transparent, and easier to track for veterans and their families. TAPS also supports the Ernest Peltz Accrued Veterans Benefits Act to ensure eligible survivors receive their veterans' unpaid pension. Last year alone, nearly 9,000 newly bereaved survivors connected to TAPS for care and services, the most in our 30-year history. 37% were grieving the death of a military loved one to illness, and many were caregivers to their veterans before their passing, which is why TAPS strongly supports the Veterans Caregiver Appeals Modernization Act, which improves the VA's caregiver support program by making the application and appeals process more accessible and efficient, and ensures much-needed financial support for survivors. On behalf of our surviving families, TAPS appreciates the opportunity to testify, and I look forward to your questions. Thank you.
Thank you, Ms. Wheeler. The written statement of our witnesses today will be entered into the hearing record. We'll now move to questioning. Mr. McGarvey?
Thank you, Mr. Chairman. We'll get right into it. Ms. Wheeler, you addressed this a bit in your testimony, but I was hoping you could tell us more about why TAPS feels that the Congressional Budget Office estimates are too high for the Caring for Survivors Act. Is there any additional light you can shed on that?
Yes, thank you, Madam Member. I appreciate that question. What we have heard from VA when the PACT Act was initially signed into law, they were looking at the potential of 382,000.
Ms. Wheeler, I'm sorry, is your microphone on? Thank you.
It is now.
Yes, ma'am, thank you.
Thank you for the question. So when the PACT Act was passed, the VA had initially predicted that there could be up to 382,000 survivors that might have benefits under the PACT Act. We have seen a record number of 37,000 apply for benefits, which still is wonderful news for surviving families. But it certainly is a big delta from what the original estimate might have been. What we have heard since then is that actually what has happened is that they were looking at all of the amounts of survivors within their database that could have possibly had benefits due to the PACT Act. And it wasn't related to cause or manner of death. So one of the pieces of legislation we've all been talking about here today would actually fix that problem by helping VA to actually code by cause of death. But this impacts legislation like the Caring for Survivors Act, because we believe the Congressional Budget Office is actually scoring it based on a much larger number than what actually is. So thank you for the question, sir.
No, and thank you for that. I mean, I think it's important we know those numbers. We have to have a data-driven approach to this while we're doing our best to take care of our veterans. I also want people to understand here that we're talking about a modest increase in the base rate for dependents in care in this bill. It's less than $500 a month for a survivor. But what does that additional money mean for survivors and dependents?
It means paying their bills. It means having a little breathing room to be able to even attend to children that are grieving as well, to take care of themselves, to just breathe a bit easier. It would really go a long way for our families and is overdue.
Mrs. Gulev, I appreciate your testimony so much. I appreciate your service. We know when anyone in a family serves, the whole family serves, and we thank you for that. We thank you for your courage in coming here today. Could you tell us a little bit about what that additional money would mean for families? Turn your microphone on. Thank you very much.
Thank you. That amount of money would make a big change, a huge change. In my case, I was left homeless in a very short time after my husband died, with nothing, destitute and no income. So $500 was a big deal. That would have done a whole lot for me in particular, and I'm sure for everyone else involved. My caregiving experience lasted so long that my life was virtually non-existent. It was the caregiver experience. So no income in savings, no 401ks, no additional input into the household income other than my husband's disability check. And when that was gone, everything was removed with it. I'd also like to add that not only was I a nurse by education and had planned to do that as a career, I went into the admin side and was a biller and coder. So working with the numbers and, gathering all of the stuff that needed was something that I was very used to. But to answer your question, $500 a month would be a very big deal to someone like me, and quite honestly, it's an even bigger deal if you have others at home.
And so many families, thank you. While we're on the subject of DIC, we're talking about these things, there are quite a few bills here that address appeals, both at the BVA and the CAVC level. Professor Wishney, rather than ask you about any specific one of them in the time we have remaining, I'm more interested in how they'd operate in concert with one another. If you've analyzed these as a total package, how do you think they'd work from an ecosystem-wide perspective?
Thank you for the question. I think each bill makes important adjustments and contributions to hopefully make the overall system work better. My own review of the bills for today suggests that they are not in conflict, and so it's not to do one bill or the other. They come at different parts of the problem. No one bill today is the AMA that's trying to do an entire makeover. But each bill contributes, I think, meaningfully to a more efficient system for families, for veterans, for all of us.
Thank you so much. I'm out of time. I appreciate all of your testimony, Mr. Chairman. I yield back.
Thank you, Mr. McGarvey. Mr. Stell, sir, recognized for 5 minutes.
Thank you, Mr. Chairman. I've got some questions that are basically explanatory or clarification, Professor Wishney. On H.R. 3835, the Appeals Efficiency Act, you covered some of this in your testimony, so this will be covering it hopefully in a little more detail, just so that we understand. Would 3835 give veterans the ability to opt out as part of a class action by either the court or the board?
So the bill right now speaks of opt-outs at the court. The court's own rules currently do not address opt-outs. That's managed on a case-by-case basis. And at the court, the classes that they have certified so far, there has not been a request to opt out, there has not been opt-out provisions. And this is because these are the equivalent of injunctive cases. And in federal court, under the rules operable there, opt-outs are rare in injunctive cases. The board, I think that the legislation, I hope, will leave to the board the responsibility to decide how to operationalize the power, and it will not micromanage that. And if the board were to determine a set of opt-out rules function best, I think that's the best first step. Let the board figure out in application just as 70 other agencies have done, how to manage that question.
Okay, can you tell us why a veteran might not want to be part of a class action?
So I don't think there are a lot of good reasons, honestly, but some veterans might prefer for their individual case to continue moving through the agency process at the RO or the board rather than wait for a decision that's class-wide, even though that decision might benefit them. And if they go through by themselves, they run the risk of a single judge saying, no, I don't see it that way. Nevertheless, they might prefer to have that option and that swifter decision. And so I could see why they might say, I don't want my claim to wait at all. Let's go forward.
Then can you talk to us about the advantages of being in a class action?
Some of the things that I mentioned, many veterans, of course, don't have access to medical or scientific experts. And maybe I'll just give a quick example. In the SCORE case itself, which I mentioned, that case arose from a group of about 1,400 airmen who responded to a plutonium leak in 1966 when we accidentally nuked a village in Spain. The bombs didn't detonate, we dropped bombs by mistake, and 1,400 airmen went out to clean up the plutonium that spilled out of 2 bombs. Eventually, the Air Force developed a formula to calculate how much radiation each airman was exposed to. And that same formula was applied to all of those airmen who then later applied to the VA when they experienced radiation-related diseases. Well, it turns out that that formula is deeply flawed. Even the VA's own review concluded it was not a good formula, not an adequate formula, but they stuck to it. When Mr. Score came forward, he was able to marshal nuclear physicists who could analyze that formula, explain its shortcomings, propose a more accurate formula that would better calculate the radiation for each veteran, and then apply that one formula to all veterans. So the benefit to a veteran, not every veteran can identify and persuade a nuclear physicist to take up their case and testify, as happened in that case, as an expert. In that example, all 1,400 of those airmen benefited from the expertise of the Princeton nuclear physicist, and the court credited it as a result.
Okay, I have less than a minute. I've got one more question for you. Thank you for that. You covered the writs, but would you just explain a little bit more about including writs as a covered proceeding for purposes of supplemental jurisdiction? How that could result in unintended limitations, if it does. Could you just quickly go over that?
Sure, briefly. Currently, the court has authority under the All Writs Act, an ancient common law power codified by the first Congress in the first Judiciary Act of 1789, to use writs in aid of jurisdiction in a narrow set of circumstances. Most cases of the court, well over 90%, are appeals, not writs. But the court has done some aggregation in the writ context, and that's working fine, I think. The Federal Circuit in SCORE was addressed to appeals, and the court there said that the Veterans Court cannot aggregate appeals because it lacks supplemental jurisdiction. That's not an issue for writs cases. It's only an issue for appeals. The Federal Circuit said you lack supplemental jurisdiction, therefore you cannot aggregate claims. This bill would grant supplemental jurisdiction. And as I suggested, I think it should limit itself to appeals, granting supplemental jurisdiction to appeals, and leave writs alone. They're working fine. There isn't a problem there.
Thank you for that clarification. I yield back.
Thank you, Mr. Self. Ms. Huliff, you currently reside in Florida still?
Excuse me?
Are you still living in Florida?
No, I'm currently living in Texas.
Well, that's a great state. Welcome.
Thank you.
We're happy to have you.
Thank you.
I totally lost my train of thought. I'm sorry. I had to bring it back up a little bit. Yeah. If you don't mind, during this period with your husband,
Yes.
you were currently residing in Florida, correct?
That's correct.
Were you engaging with one specific VA and one specific VA only, or were you actually, did you travel? I'd like to, if there's anything I like to do is pick apart the VA, okay? Because
Go ahead.
there's a large problem set, but I need to know how we can kind of dive into this because your story is, and I've read your testimony twice. Were you dealing with one specific VA?
For the vast majority of the time, we were in West Palm Beach. And then in 2018, and bearing in mind he died in 2022, we moved further north to Volusia County, so we were within the Orlando system there. So it was 2, but 99% of his
When you made the move, I'm just going to correct me if I'm wrong on this, but did everything almost have to start over because you went to a different VA, or was there a good information communication flow between the two?
My husband did not want to start over because it's my understanding and has been my experience that when you move from one VA, each VA seems to be its own universe, and he did not want to start from scratch. So he requested, and I fulfilled that request. We drive over 200 miles each way from Daytona Beach to West Palm Beach to see his.
So you stayed at the same VA?
We did, yes.
Okay, and do we have the list of individuals that you talked to, name-wise, specifically? I'd like to unpack this in a way to kind of, almost to the granular level, to see why this happened.
Okay.
Because it was over a 5-year period. After you met with one of the appeals court, you met with one of the board members, or you met with a judge that you said?
And that was just in December of 2024. Before that, all of our appeals process had been back and forth on paper, so to speak.
And what was the judge's response to you? Because then, a few months later to a year later, you got the results that said you've been declined?
Yes.
Can you tell me exactly what the judge's engagement with you was?
When I got to the judge, the very first thing he asked me was, how did you get to me? Because he, in his experience, had never had a survivor or someone get to his level. It was usually done through a much different process. Again, I don't know much about that. But shortly in the hour before I saw him, it was done virtually. I had to go to the Houston VA, who told me that my husband did not exist. No such record of him. He doesn't exist at all. No, sorry, you're in the wrong place. I said, well, maybe since I have all the powers of attorney, maybe you can check my name, because I was the point of contact for the VA for many, many years. Nope, you don't exist either. There was
This is the Houston VA? I'm assuming you're talking about DeBakey?
Yes.
Okay.
They refused to let me in. I said, well, I have a hearing with the judge, and you are going to let me in, because when the screen opens, I expect to be there. There was quite a bit of back and forth, and I had to be escorted by the Houston police to get me in front of that judge. And when the judge did see me, he wanted to know where my representation was. And I had to tell him, I don't have any. I built this case by myself. And he ran through all the list of the potentials, who, this group, that group. I'm refused, denied.
How did we end up in Houston after leaving West Palm Beach and Orlando?
Shortly after my husband died, our mortgage holder, it was a VA mortgage, called and asked when I would be vacating my home, because my name was not on the mortgage. I may have been on the deed, but I was not on the mortgage. And since I had not had a working job with an income since 2010, because I was caring for my husband, I wasn't qualified for a mortgage or credit of any kind. So the mortgage holder asked me when I would be vacating or if I would be buying my house back from them.
So when you got to Houston,
Right.
which again, it's very challenging for VA facilities to communicate with each other. That's no
Right,
hit. That's
yeah,
no
very-
secret.
Very difficult.
West Palm Beach would not communicate with Houston, DeBakey, that says, hey, yes, we've absolutely know who this person is.
Correct.
They did do that, or they did not?
They did not.
Did you ask them to do that?
Oh, yes. Unfortunately, I had to get a little bit strong with the people in Houston.
Oh,
I
did you get in trouble in the VA?
On more than one occasion, I'm afraid. No is not always the correct answer. But on this particular occasion,
And I understand what you're saying, but it probably didn't come out right. But
But I had luggage
Yes,
with
ma'am.
all of the paperwork and documentation that I was supposed to be there on that day. So after a few lengthy conversation with more than a few people, including the Houston Police Department, they granted me access to the room where the screen was, where the judge was going to hear my case.
Okay, the judge's responses to you was, this sounds absolute, you're good to go, but then,
He was shocked that I had no representation. He was wondering how this could even happen. After he asked me my questions, I spoke to him at length. There was more than a few Kleenex passed around the room on that day, but he asked for hundreds of pages of documents. I said, I will give you everything you want, all of the documents, all of the evidence, everything on this case. It's about 180 pages, the short version. He asked for all of it. I mailed it, I emailed it, I digitized it, and I got it to him. But as I told the judge, I said, when someone gets a stack that big on their desk, most of the time it's unmanageable to look through all of that stuff. He assured me that he would look at it and that others would look at it. It is my understanding that that did not happen, and he was not allowed to read my evidence that he asked for based on the rule of law that, once my husband was gone, so was the case.
okay. Mr. Edwards? In accordance with committee rules, I ask unanimous consent that Representative Edwards be permitted to participate in today's subcommittee hearing. Mr. Edwards, you're recognized for 5 minutes, sir.
Thank you very much, Mr. Chairman and committee members, ranking member, and all of you. I appreciate being waived on and allowed to speak today. As the proud representative of North Carolina's 11th District, a district home to over 50,000 veterans, including many who served in the 82nd Airborne and across the armed services at Fort Bragg, I introduced this bill because we're failing our nation's veterans in one of the most critical ways imaginable. We're not fully accounting for the true cost of the mental health crisis in their ranks. For years, we've heard the number, 22 veteran suicides per day. But emerging data from groups like America's Warriors Partnership suggests that number may be closer to 40, or nearly 15,000 veterans every year. That's simply a tragedy. And it's a failure of policy, data, and accountability. Our veterans deserve better. We can't begin to address the veterans' mental health crisis without first having accurate data that helps us fully understand the scope, severity, and the nuances of the crisis. My bill, the Justice for Americans Veterans and Survivors Act, will finally ensure that we collect and report accurate, comprehensive information about how and why our veterans are dying. This includes tracking suicides more precisely, identifying when overdose or self-harm is involved, and clarifying the role of service-connected injuries and mental health conditions. A tragedy that many spouses have to endure after their service member's death. Currently, the Department of Veterans Affairs relies heavily on county-level reporting, which misses nearly 1 in 5 veterans. Families are left without closure. Survivors are often denied the benefits and support that they deserve. And policymakers, us, are left trying to fight the crisis blindfolded. This bill changes that. It brings transparency, it brings accuracy, and most importantly, it brings justice to the men and women who served and to the families that they leave behind. In Western North Carolina, we feel this crisis personally. My team and I have sat with families who've lost a loved one to suicide. We've met with veterans who are still fighting daily battles that we cannot see. And this bill is about making sure that their stories are counted, their struggles are acknowledged, and their families are supported. I'm grateful for the strong bipartisan and community support that this bill has received from organizations like the Veterans of Foreign Wars, Military Officers Association of America, Paralyzed Veterans of America, and Tragedy Assistance Program for Survivors, and for members on both sides of the aisle who agree that this crisis demands action. Passing this legislation is not a courtesy to our veterans, it's a commitment to the truth, to accountable, and to the sacred promise that we make to all who serve, that when you come home, we'll continue to stand by you. This legislative hearing is just the first step towards fulfilling that commitment. Thank you again for the opportunity to speak, and I urge this subcommittee to move swiftly in advancing this legislation. Mr. Chair, I yield.
Thank you, Mr. Edwards. Thank you for the testimony from the panel. You're now excused. And will the third panel please be seated? Dr. Richardson, are you ready? You look ready. You stay ready so you don't have to get ready? Okay, good. All right. Is everyone ready? Thank you to the witnesses for joining us today from the Department of Veterans Affairs and the U.S. Court of Appeals for Veterans Claims. The lead witness for VA is Mr. Evan Dykert, acting Deputy Vice Chairman and Veteran Law Judge at the Board of Veterans Appeals. Mr. Dykert is accompanied by Mr. Kevin Friel, Executive Director of Pensions and Fiduciary Services at the Veterans Benefits Administration. Mr. James Smith II, Deputy Executive Director of Policy and Procedures for Compensation Services. And Dr. Do you prefer Colonel? Okay. Dr. Colonel Colleen Richardson, Executive Director for the Caregiver Support Program at the Veterans Health Administration. I have to ask, military guys? Well, you're sitting in the wrong spot. Let's do one of these. No, sir. One of their names is Colleen. What? Yours says Colonel in front of you. Is that wrong? I said Colonel. Everybody leave me alone or I'll freak out.
We got a Colleen and then someone who's a Colonel.
Oh, all right. Sorry, my fault. Dr. Colleen Richardson, my fault. Yes, ma'am. I know how to fix this problem. Dr. Colleen Richardson, Executive Director for the Caregiver Support Program at the Veterans Health Administration. Welcome. And joining us from the U.S. Court of Appeals for Veterans Claims is Colonel Tiffany Wagner, Clerk of the Court for the U.S. Court of Appeals for Veterans Claims. All right, got it. All witnesses, please stand and raise your right hand. Do you solemnly swear that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth so help you God? Thank you, and let the record reflect that all witnesses answered in the affirmative. Mr. Dykert, you are now recognized for 5 minutes, sir, to present the department's testimony.
Good afternoon. Chairman Luttrell, Ranking Member McGarvey, and members of the subcommittee. I appreciate the opportunity to appear before you today on behalf of the Department of Veterans Affairs to discuss how VA strives to achieve final resolution of veterans' claims and appeals, to ensure access to VA health care and benefits, and to provide VA cemetery or burial benefits as well. Accompanying me today are Mr. James Smith, Deputy Director of Policy and Procedures for Compensation Service, Mr. Kevin Friel, Executive Director of Pension and Fiduciary Service, both in the Veterans Benefits Administration, and Dr. Colleen Richardson, Executive Director of the Caregiver Support Program, Veterans Health Administration. While VA's views on all the bills are detailed in my written testimony, including areas of concern and support, I would like to highlight some of the bills in my opening remarks. First, VA supports the intent of the Justice for America's Veterans and Survivors Act, subject to the availability of appropriations, but cites concerns with the level of data tracking required by the bill. While VA recognizes the tragedy of veteran suicides and aims to identify any links to service-connected disabilities, VA already reports comprehensive mortality data annually, including leading causes of death and receipt of care and benefits. VA is concerned about the feasibility of tracking new data elements mandated by the bill, especially those not currently collected by our systems. For instance, determining if a suicide is directly related to a service-connected disability like PTSD can be challenging without specific death certificate codes. Additionally, if the veteran did not die in a VA facility or receive VA benefits, VA may not have information necessary regarding that veteran's cause or manner of death. We would appreciate discussing the bill further with the committee to clarify the intended outcomes and consider necessary amendments to ensure we can accurately report the required elements. VA does not support H.R. 659, the Veterans Law Judge Experience Act. This bill would require the board chairman to prioritize candidates with at least 3 years of experience in laws administered by the secretary when recommending individuals for veterans law judge positions. The current selection process for veterans law judges is based on merit and fitness for the role, akin to the standards for judges on the Court of Appeals for veterans claims. Prioritizing specific types of experience could undermine these merit-based principles. VA has appointed a diverse group of highly qualified judges, many of whom had no prior VA experience, but brought significant military or judicial backgrounds. This diversity has helped VA achieve record levels of appeals adjudication, offering the best service to veterans. VA believes it is crucial to maintain the flexibility to select judges based on a wide range of qualifications, ensuring the highest standards for serving our veterans. VA supports the Rural Veterans Improved Access to Benefits Act, subject to amendment and the availability of appropriations. We appreciate the committee's efforts to improve temporary licensure requirements for contract healthcare professionals performing VA disability examinations. VA recommends removing the sunset date on these licensure requirements. This would provide greater flexibility to engage a broader range of qualified medical professionals, especially in rural areas, resulting in shorter wait times and faster examination completions for veterans. In addition, VA recommends removing the reporting requirement to disaggregate timeliness data by healthcare professionals. VA does not have access to the specific data from our vendors' proprietary systems, and controlling factors outside our individual examiners' responsibilities may skew the data. It is important to note that VA may return examinations to be reworked for reasons other than error. Additionally, VA tracks timeliness from vendor acknowledgement of examination request to completion, not by individual examiner activity. Mr. Chairman, please understand that the concerns that we have raised in our written testimony today and that will be raised in our testimony that's oral is sincere. VA understands that the appeals process can be long and frustrating for many veterans, but I hope that the answers that we can provide to your questions will help explain why it takes so long to process an appeal or a claim and what VA is trying to do about it. Ultimately, processing these appeals takes time because each and every case represents a veteran with a unique set of facts and circumstances. VA shares Congress's goal of continuous improvement to both our program and our customer service to veterans, their families, caregivers, and survivors. We want to express our appreciation for your continued support, and we look forward to continued collaboration. Chairman Luttrell, Ranking Member McGarvey, this concludes my statement. My colleagues and I will be happy to respond to your questions.
Thank you, sir. Colonel Wagner, you're now recognized for 5 minutes to present the testimony of the U.S. Court of Appeals for Veterans Claims.
Chairman Luttrell, Ranking Member McGarvey, and members of the subcommittee, thank you for the opportunity to testify today. I am appearing on behalf of Chief Judge Michael P. Allen to offer the court's perspective on the proposed Veterans Appeals Efficiency Act of 2025, specifically Section 2E, which proposes to expand the court's jurisdiction and define the court's limited remand authority. I had the opportunity to appear before this subcommittee regarding similar legislation in April 2024. As I noted then, the court cannot comment on the advisability or scope of proposed changes to our jurisdiction. Such matters are squarely within the purview of Congress. Likewise, the court does not offer advisory opinions or suggested language on legislation it may one day be asked to interpret. That said, we can offer general observation on the bill's language and possible implications. First, regarding supplemental jurisdiction. The proposed language in subsections of 38 U.S.C. Section 7252 aims to broaden the court's class action authority and allow current claim processing between the court and the VA. While this may provide new pathways for veterans, we offer a general caution that some of the language as drafted is somewhat unclear. For example, broad references to terms like claim, notice of disagreement, or supplemental claim, without specific citations or context, make it difficult to determine the intended application. Additionally, the inclusion of writs under supplemental jurisdiction may raise legal complexities and could unintentionally limit the court's existing authority under the All Writs Act. Furthermore, the proposal to toll the deadline for appeal filings introduces a new category of jurisdictional questions, which could increase the court's caseload. Given that our court is already handling a record volume of appeals, such growth would likely require reassessment of both resources and procedures. Second, on the matter of limited remand authority, the bill proposes a statutory framework under 38 U.S.C. Section 7252C, which appears intended to codify the court's authority. The court already possesses limited remand authority, and by defining in statute when and how limited remands may be issued, the legislation could inadvertently narrow the court's existing discretion rather than expand it. We raise these points not to oppose the bill, but to help ensure that any changes fully reflect Congress's intent and avoid unintended constraints on judicial flexibility. In closing, the court remains committed to delivering full, fair, independent, and timely judicial review to veterans, their families, and survivors. We appreciate your continued efforts to improve the appeals process, and thank you for including the court in these important discussions. I'm happy to answer any questions.
Thank you, Colonel. The written statement of the witnesses will be entered into the record. Mr. McGarvey, you're recognized for 5 minutes, sir.
Thank you, Mr. Chairman. Thank you all for being here today, and thank you for your testimony. Mr. Friel, I'm going to start with you. And with the VA's testimony on H.R. 3854, the Modernizing All Veterans and Survivors Claims Processing Act says that VBA, and I quote this, is working to identify solutions in the claims process where benefit adjustments can be made using technology without human intervention, unquote. I'm not against technology. Technology has a wonderful place. But I think you can see that I have some pause on the VA moving toward true end-to-end automation. There are mistakes that are made with machines, and of course some of our veterans have some problems navigating these systems already, as we've heard from many of them. Certainly I have in Louisville, Kentucky. I think a lot of those beneficiaries, and we're talking about our veterans, right? We're talking about the people who've served us. They want and need a human backstop to any decision that is made. But more importantly, that quote makes me question whether the VA intends to replace the people who work for the VA, not just give them additional tools that are going to help our veterans get their claims processed. Can you tell me right now that the automation and pension fiduciary service will not lead to a replacement of or reduction in the VBA workforce?
Yes, sir. Thank you for the question. We have been automating since 2014. In reality, this year we're on target to automate over 320,000 claims. We have not removed any individuals, any employees have lost their job because of automation. They may have been reassigned to maybe work compensation instead of pension or fiduciary, but we have no intention right now that I know of, that I'm aware of, to remove anybody because of what we're doing in automation. But to give you an aspect, in an automated world, we have cases where a DIC claim came in, and 9 hours later, we had awarded the benefit and sent out the letter and everything else to the surviving spouse with no human interaction. And that's truly, talking about getting benefits out as quickly as we can, that's one of the goals we have, is to make it. But the human will always be needed because of the complexity of some of the claims, right? Some of them are much more complex than what we could do in an automated space.
And the difficulty some people have in applying for the claims in the first place and might need someone helping, and we're trying to get our veterans what they need. I appreciate you said no intention to, but just to drill into it a little further. Everybody at VBA is going to still be at VBA next year?
So that's above my pay grade, and I'm prepared to talk to the legislation, but I am not prepared to talk to the
Again,
staffing.
what we're trying to do is, this committee, my sole focus on what's best for our veterans. How do we make sure that they're getting everything they are entitled to and they deserve? I want to make sure that that happens. I am not anti-technology. I think we can use technology to help our veterans to get those claims processed quickly. But when there are difficulties in the process, which inevitably there are going to be difficulties, even with automation, we got to have people there who are ready to help our veterans. I want to make sure that they are. Along those same lines, have you talked to veterans? Do you guys, I mean, because I know what I hear on the ground. I know when I go to veterans events in Louisville, Kentucky, what I hear from the veterans, right? And that's why I'm bringing those concerns here today. Do you have any data that says the veterans and other beneficiaries are like the automation or the algorithms that are calling the shots?
So I can speak from what we've done in our space, and I would let Mr. Smith talk about what happens in the compensation space. We have received great feedback from VSOs and organizations like TAPS in the area where we can. We actually have, based on a law passed by Congress, the ability to pay a surviving spouse based on evidence of record at the time of a veteran's death. We automate those claims. So we would pay the month of death payment, the burial payment, and if the veteran meets the requirements for 1318, we'll pay DIC payment without an application. And that's just based on the surviving letting us know that the veteran has passed away, and we validate the information, and it happens. So we've gotten great feedback from VSOs, that people get an award without even putting in an application. We wish we could do that for more, but we have limited based off of what data we have. And Mr. Smith could probably talk more about the compensation side of it.
So for the disability compensation, the automated decision support technology leverages technology to deal with the administrative burdens of claims processing. So it works on being able to pull in those digital records from VHA. It works on going out to folks to pull in private medical records, things of that nature. It allows the claims processors to focus more on the complexity and the analysis necessary to be able to deliver quality decisions.
Thank you. And I am out of time. I'll yield back, Mr. Chairman.
Thank you, Mr. McGarvey. Mr. Self, you're recognized for 5 minutes, sir.
Thank you, Mr. Chairman. Colonel Wagner, can you describe how aggregation has helped the court be more consistent in the past? I understand you have concerns about the future, but in the past.
Yes, thank you for your question, Representative Self. The court's, first of all, the court's concerns about the current statute isn't, we don't want to speak about the authority to expand our jurisdiction or narrow it or broaden it. That's within Congress's purview on that. So the court doesn't want to speak about that. The issues we brought up about the current legislation deal with some of the language that appears ambiguous, and we don't want to interpret it. So we wanted to highlight that. The court has tried, the court does have an active class action process where we aggregate cases. Currently, we have received 26 requests for class certification, and the court has certified 5 of those. 10 were denied, and the rest, the 11 other, were either dismissed, they were either reached a negotiation on their own, or something like, or it's still pending. So the court has used it, as you know, and what was brought up by Professor Wishney is that the Federal Circuit has determined that our authority needs to be a little bit narrow, and there was a case where the court, the Federal Circuit determined that the court went a little too far. I hope that answers your question.
Well, the consistency was what I asked about. Has it improved the consistency of the decisions?
Yes, I believe so.
Okay.
I can get back with you some more details on that, but I think that a lot of those answers about the consistency would have to be answered by the veterans who've experienced it, and how it affects additional future case law.
Well, would the authority, as outlined in the bill, approve efficiency then? Let's talk about that. Are you willing to opine on that?
Yes, aggregation would increase efficiency.
I yield back, Mr. Chairman.
Dr. Richardson, I got you. If the veteran passes away while their caregiver is appealing their application to join the VA Caregiver Support Program, what happens to the appeal?
Sure, thank you for the question, Chairman. So it depends. As long as we have the information available to us, so certain requirements are met, and we have enough evidence or information, we are able to render a decision and retroactively
Does
pay.
that information have to live and breathe in one specific site? Because from the way I understand it, if an individual moves from their location where they reside to another one, doesn't seem like the information flow, it seems like the information flow is broken.
We have access to JLV, which allows us to access all data and all health records for any veteran in our system.
I don't know if I exactly believe that statement right there. Does the guidance and training for evaluating applications to the VA Caregiver Support Program that VHA employees receive match the guidance and training that VBA's employees receive?
Thank you for the question, Chairman. So the adjudicators for VBA is different for the appeals that they file through the Caregiver Support Program. So you have the board appeals, then you have AMA, and supplemental, so you have supplemental claims and higher level reviews that VHA does within the Caregiver Support Program. So the level of training that we do for our appeals staff is the same training that we give all of our staff who render any type of initial decision or any type of appeal decision.
Say more.
So when a veteran and caregiver, a joint application is submitted to the Program of Comprehensive Assistance for Family Caregivers, all of those folks who make those initial decisions on those original applications get the same level of training on standardization, consistency, how to apply
Across the VA?
across the Caregiver Support Program. So within my program, I have staff at the VISNs called SEAT teams, Centralized Eligibility and Appeals
How many
teams.
personnel do you have under your,
Roughly about 2,200, sir.
across the country?
Yes, sir.
And they all come to the same spot, or is this a virtual training now since COVID, whenever that happened?
It is a virtual training, yes, sir.
Okay.
So the folks that make those initial decisions on applications are stationed at the VISNs. Those that render decisions on appeals are stationed at the VISNs and within VA central office under me, under my program office. So higher level reviews, supplemental claims are decided in VACO, and the VHA clinical appeals process is done through the SEAT teams.
If a veteran dies while their caregiver is pursuing an appeal, is that family caregiver eligible to receive any unpaid stipends owed at the time of the veteran's death?
Yes, they are, as long as we have information that is available to us. So it would help if I just explained. So when a veteran and caregiver apply to the program, there are certain steps that they must follow. Certain eligibility requirements must be met, and at any point along the way, if they don't meet eligibility requirements, they are denied at that step.
Is there one, let me ask you this, forgive my interruption.
Sure.
Out of the laundry list of checks in the boxes that you have to have, if they miss one, they're done?
They are denied at that point in the process, yes. So just because the veteran passes away doesn't mean that we don't give retroactive benefits. It's only if we don't have that information available to us to render that decision. So, for example, Mr. Chairman, if a veteran and caregiver are denied because it is deemed that the veteran doesn't need in-person personal care services, it doesn't make clinical sense to have the caregiver go through training. It doesn't make sense to do the caregiver assessment, the veteran assessment, go into the home on that particular application. So they're denied at that point in the process.
I would be willing to bet every caregiver that's living in a home with a veteran in need will disagree with what you just said.
So if they don't meet program requirements for PCAFC, we enroll them in PGCSS, our Program for General Caregiver Support Services, and we continue to help them as a caregiver in the journey of that particular veteran and his or her needs. That's why we have the two programs, sir.
How long, what's the and you can give me a range here.
Sure.
I'll give you some latitude. What's the window of confirmed or denied when a caregiver reaches out to the VA for this kind of support?
So today we render decisions, probably 9,000 applications come in a month, about 30% of those are approved for the program, 30 to 33%.
What's the turnaround time?
86% of applications are adjudicated,
No, I'm sorry, window, like if I give it to him today,
Yep.
he's gonna give me a response tomorrow?
86% are done in under 90 days.
90 days?
Yes, sir.
So when we have the 4 or 5 years, that's a anomaly?
Those are for applications. When we're talking appeals, different discussion. So VHA
Okay, so
clinical
let's walk back
appeals.
to application real
Yeah,
quick.
Sure.
How long does an application normally take?
86% under 90 days.
90 days?
Yes, sir.
Okay, so 3 months. And then if it has to go into appeals, does it get lost in the metaverse?
It does not. So understand that the VHA clinical appeals, roughly, you have 2 levels of VHA clinical appeals. Most of those decisions are done in under 45 days, level 1 and level 2. Now you come over to the AMA side, which we had to implement back in 2021. We had to notify 450,000 veterans of their new rights to appeals as a result of a court case that happened in April of that year. We mailed out those applications in November of 2021 with no staff on board, and by late summer of 2024, we finally had permanent staff on board. Today, we adjudicate more appeals that come in our door than we receive. So in a very, very short time frame, our team has turned around the number of appeals coming in our door than what we have originally received, if that makes sense. So we started behind the power curve with appeals, AMA appeals.
Don't answer this question that I'm fixing to ask you, but why is this process so weighted and so challenging for our veterans and caregivers? We had a young lady she's sitting in the chair just to the left of you, but just reading her testimony and hearing her in here today, it seems extremely burdensome. Now, I know the VA has to protect itself, and a lot of times that's how this is created. But have we gone too far too fast and got out ahead of the veterans where they can't keep up? Don't answer that question. Mr. Dykert, the board reports quality rates of roughly 95%. But the court reported last year that 83% of board appeals were returned to the board because of legal errors. What accounts for the discrepancy between these two numbers?
Thank you for the question, Chairman Luttrell. When we had the Court of Appeals for Veterans Claims Conference in September, I made the point that I'm about to make to you, and that is that a case is fundamentally different when it comes before the Court of Appeals for Veterans Claims than it often is when it's before the Board of Veterans Appeals.
We're talking about the same veteran.
Yes, sir. Because...
Okay, let's make believe I'm not an attorney, but I have one sitting here and he's listening.
Absolutely. So what oftentimes happens is Mr. McGarvey, Esquire, is not generally there with you at the board level. So that's not impugning anything that any of our VSOs do. But veterans most often get attorneys when they get to the court level in terms of providing them representation. So that attorney is able to go deeper into the file. They have an incentive to ensure that they are looking at every individual thing that could be there. And that case is different when it's presented by an attorney before the Court of Appeals for Veterans Claims than it may have been as it came up through the Board of Veterans Appeals and even VBA before that.
Is that an extra step that doesn't need to exist for a 10% delta between those two numbers?
In terms of the representation at each different stage, we certainly welcome additional attorney representation before the Board of Veterans Appeals. Those numbers have been rising.
Veterans know that? Is that something that we populate?
I think it's getting out there, to be honest, because the number of appeals that we have that have veteran representation by attorneys at the board is increasing year over year. And I can tell you, sir, that as a person who adjudicates those also look fundamentally different than if they come directly from the American Legion or a state veteran service organization. You're packaging everything, lawyers are packaging everything in the way that another lawyer knows how to look at it. So they're able to say, on page 424 of this record, you can find this information. They're able to say, based on this regulation, this is the action that you should take.
Mr. Self, you get Ms. Hayes, I'm sorry. Okay. I apologize, I went long. Thank you. I recognize, Ms. Hayes, you're recognized for 5 minutes.
Thank you for allowing me to be here. I'm not sure if the witnesses heard my opening statement earlier, but my bill, the Caring for Survivors Act, would modernize survivor benefits to ensure families receive the financial help they deserve. I recognize the cost concerns of implementing this legislation. However, the cost is likely lower than the current reported estimate, which is based on outdated data from the PACT Act, which was passed in 2022. VA data shows that of the 382,000 survivors originally estimated to be eligible for benefits in the PACT Act, less than 10% have submitted claims nearly 3 years after the bill has been passed. Accordingly, the number of survivors that will apply for benefits under the Caring for Survivors Act is also likely far less than the number of eligible individuals included in the current cost estimates. Having a better estimate of the number of survivors who will likely apply for benefits will allow for a more accurate cost estimate of my bill. Mr. Deeker, my question is, does the VA know how many survivors are likely to apply for DIC benefits under the Caring for Survivors Act? And is it fair to assume that we may see the same 10% rate of survivors that have submitted PACT Act claims compared to the original estimates on the number of eligible individuals? Would that also apply to this bill?
Representative Hayes, with respect, I'm going to defer to Mr. Friel on this.
Okay.
Ma'am, thank you for the question. As it relates to the PACT Act, we identified, we didn't have the causes of death, so we identified all beneficiaries where DIC had been denied. We sent out over 300,000 letters as required by the law. We were expecting a higher rate of return, but it didn't come in that high. Today, we are seeing, an increase year over year in our population within the DIC program. The issue with determining the cost of it, the first part is, we agree, and with the bill we supported pending appropriations that, the increase of the DIC rate to 55% of the 100% rate. The second part of it is a lot more complicated. It says to treat 5 years as it relates to 10. So our interpretation of that means that we would be 50% of the DIC rate if they were at 5 years of the 100%. We don't know what congressional intent is, so if it's 5.5 years, what's that number, right? So that's part of the clarity we need. The other part of that is any of those survivors that we would grant DIC to, say, on the reduced DIC 1318 rate, would then have to be adjudicated for DIC because it would be a higher rate. So we would have to still do the research and get the information to see if they are, in fact, eligible for the full DIC rate. And then we also would need clarity on what the intent is for the other parts of the benefit. So if at 5 years we're going to give 50% for DIC, what if there's a child? Does that mean it's 55% or 50% of the child rate, or is it do they get to the 100% of the child rate? There's a lot of things there. We would be more than happy to sit down with your staff and work through some of the issues we have and being able to develop a costing for that.
So is it possible, and I really want this legislation to see the light of day because it is so important. And I guess just saying it would cost too much or we don't have the information just doesn't feel like an appropriate answer to me. I would propose that we say, under this scenario, this is what would happen. Under this scenario, this is what would happen. These are the number of people who are eligible. If 50% applied, this would be the number. If 10% applied, this would be the number. Because I believe that ultimately having the best data that reflects the likelihood of participation in the program will give us as members of Congress the information that we need to at least explore options here. And like I said, I'm back again trying to push this legislation because the families, the survivors, the children, they need it. It's long overdue. And if we don't have the data, I feel like we have the facilities we have the information. All we need to do is pull it together and disaggregate it.
And I think we could give you information for the first part, right? The 100%, 55% of the 100. It's the second piece that's really difficult because they may come in and say, okay, you're 50% today, but oh, by the way, when we adjudicate the claim, now you're entitled to.
We're the United States of America. There's nothing beyond our capacity.
I didn't say it was beyond our capacity. I just said for our purposes, we need clarification of the intent of that section, and so then we could sit down with our budgeting people and kind of get a better scenario of what it looks like and how that would play out.
Well, I'd love to continue to work with you to try to get as much good data as we can to make the best possible case. Thank you again for allowing me to join this committee, and I yield back.
Thank you, Ms. Hayes. Mr. McGarvey, sir.
Thank you, Mr. Chairman, for letting me ask just a few more questions. I want to start kind of back where we were when I was asking questions last time. We were talking about some of what's happening at VBA and doing what's going on. So, Mr. Dykert, I want to start with you. What we were talking about, some of the things that are happening with automation and whether our veterans are fully getting taken care of. And this leads me to something that might be related, might not be related, but I want to ask about it. There's a May 27th bulletin from the Chief Human Capital Officer extending the probationary period of all Board of Veterans Appeals employees hired after March of 2024 for an additional year. And let's talk about what this means in plain English. If you're a probationary period, you're there for a year. And then after a year, you're no longer on your probationary period. So if in March of 2024 you were hired, or in April of 2024 you were hired, you're out of your probationary year. Then May 27th, a bulletin is issued saying, no, you're still in probationary year. Was BVA consulted prior to this decision? And if so, what was their feedback?
Thank you for the question, Ranking Member McGarvey. I cannot say whether the board was consulted with regards to this particular memo. It's something I'm certainly happy to take back for the record, but I'm not aware at this time of whether we were consulted.
Okay, I'd love to know if you were consulted and if there was feedback, so please get back to us on that. And it's also my understanding that this applies to all probationary employees at the board, irrespective of their actual performance during the preceding year. Is that correct?
I'm going to have to claim a little ignorance, and if you'll permit me to tell you why. I had knee surgery 3 weeks ago, and there's been a lot of movement in this. And so I know that I have missed some of the emails explaining exactly how this is going to play out and exactly what we're going to do with it. So between recovering from that, preparing for this, I don't have the specific information that I can give you at this time, but it is, again, something that I'm happy to get back with you on, sir.
Can anybody answer that question? Nobody can answer that question. Okay,
One thing I can say, Representative McGarvey, even under that Ochiko memo, I know that it did have a carve-out for those who have a veteran's preference. So if you had a veteran's preference, your probationary year stayed at 1 year.
Because the purpose of a probationary period is to make sure that employees are learning, that they're progressing well enough to be granted full employment. There are people who have worked there who are finished with their probationary year, to our understanding, that now are back in a probationary year, which is it BVA's position that absolutely none of the employees that hired during the last year passed that muster?
So we will follow whatever guidance we are given by VA's Ochiko, but that doesn't mean that anybody who is at that point hasn't passed muster. We evaluate our attorneys, especially our new attorneys, on a consistent basis throughout their probationary year. If that becomes 2 probationary years, then we evaluate them consistently through that entire time.
Yeah, and again, we talk about these things in such technical terms. Let's really phrase what's happening here. There are people who signed up, they knew they'd get a probationary period for a year, they served that probationary period for a year, now they're back under a probationary period for another year. Why under a probationary period, especially if they are doing a good enough job? And one of the things that happens when you're under a probationary period is you're easier to fire. You don't have the same civil service protections that someone who is no longer in a probationary period has.
Yep.
So I just got to ask bluntly, is BVA planning, or does it intend to plan, a significant reduction in force at the Board of Veterans Appeals?
In terms of anything that may be coming down from VA on high, I can't answer that. I do not know what overall plans are. What I can say, as it comes to the board specifically, we hired staff, we hired attorneys because we needed them to do the adjudications, to deliver answers to veterans. We invest a lot of time, a lot of money into training them, into getting them up to speed. It would not be my intention, if anybody is doing well enough to be retained, to do anything other than with them than to retain them.
And look, I appreciate that. I believe you. I hope your knee's feeling better. The answer's still not satisfactory, right? What you're telling me is you can't tell me whether that's happening or not. And what I do think we all agree on is veterans need the best possible care. They need the best people working on their claims. It's helpful when they have attorneys working on their claims. We are now making it easier to fire people who should be there no matter what. And let's just be honest about it. That makes it harder to recruit, to retain. It hurts morale. It hurts the people who are working there. And who does that ultimately hurt? Our veterans. That's who it ultimately hurts. That's why we're concerned about this. That's why I want you to get back to us with those answers, because we don't want to hurt our veterans. So, Mr. Chairman, you've been very kind. I yield back.
Whose role is it in the appeals process to ensure that the board's decisions or remands are correct, fair, and timely, person-wise?
I'm sorry, Chairman Luttrell, could you?
Whose role is it in the appeals process to ensure that the board decisions or remands are correct, fair, and timely?
So there is no one individual entity that would say.
Entity or person?
Neither.
Seems like a problem.
So.
Doesn't it?
What specifically, sir, would you be envisioning? That in terms of.
Oh, that's why I'm asking you.
Well, I mean, veterans law judges will issue a decision, will issue a remand based on.
Whose role is it in the appeals process to ensure that the board's decisions or remands are correct, fair, and timely?
So it's the individual veterans law judge's role to ensure that all of those things.
That person?
Yes, sir.
Specifically?
Yes, sir.
Okay. Are we sure?
So certainly we have a quality review process. They select a statistically significant number of cases to review to determine whether there are any number of 3 errors.
Out of what's the end value of that evaluation?
I believe it's 5%, but don't.
Of how many?
Out of all of the total number of decisions that are dispatched.
What's that annually?
So this year we're on track for 118,000. So, well, we're always told not to do math in public, but we'll go the 5%. Yeah, look at about 6,000 cases that the board's Office of Assessment Improvement will look at this year.
Is that a high enough number, just out of curiosity? 5% out of 108? I mean, you would think you would be pushing over 20 just to get a good margin of error.
Any person that you would have in the Office of Assessment Improvement looking over those numbers is also a person who is no longer drafting cases or a judge who is no longer signing them.
How many people are doing that?
I do not know, sir. I can get back to you on that.
Rough guesstimation?
We now have.
A couple of hundred?
What's that?
A couple of hundred?
6
people? 6 people?
Yes, sir.
6 people. Don't make me, I'm not gonna laugh. I'm not gonna laugh. That seems like a problem, right? That seems like a problem.
It's certainly.
You don't have to answer that question. I'm not gonna put you on the spot, sir. All right. Thank you. Thank you all the witnesses for testifying today about these important proposals. Ranking Member McGarvey, would you like to make a closing statement? I look forward to working through these issues with the department and my colleagues on this subcommittee. The bills discussed today will provide important improvements for veterans, caregivers, and survivors navigating the VA claims and appeals process. I ask unanimous consent that the statements for the record we have received be entered into the record. Hearing no objections, so ordered. I ask unanimous consent that all members have 5 legislative days to revise and extend their remarks and include extraneous material. Hearing no objections, so ordered. I thank the members and the witnesses for their attendance and participation today. This hearing is adjourned. I like that. Okay.
Roast man.